3, 2, 1, start. The question that arises for consideration is that when there is a substantial dispute as to liability, can a creditor prefer an application for winding up for discharge of that liability? Question mark. In such a situation, is there not a duty on the company court to examine whether the company has a genuine dispute to the claimed that question mark a dispute would be substantial and genuine if it is bona fide and not spurious, speculative, illusory, or misconceived. Stop. The company court at that stage is not expected to hold a full trial of the matter. Stop. It must decide whether the grounds appear to be substantial. Stop. The grounds of dispute, of course, must not consist of some ingenious mask invented to deprive a creditor of a just and honest entitlement and must not be a mere wrangle. Stop. It is settled law that if the creditors that is bona fide disputed on substantial grounds, the court should dismiss the petition and leave the creditor first to establish his claim in an action, lest there is danger of abuse of winding up procedure. Stop. The company court always retains the discretion, but a party to a dispute should not be allowed to use the threat of winding up petition as a means of forcing the company to pay a bona fide disputed that para. Learned counsel for the respondent further submitted that the mere fact that the petitioner has not been able to prove his entire case in the civil suit filed itself shows that that is disputed and not admitted. Stop. As against the decree of the entire amount claimed by the petitioner and passed by the civil court. The learned lower appellate court, while accepting the plea raised by the respondent company, reduced the decretal amount while granting relief regarding the debit notes issued by the respondent company. Stop. As there was error in the judgment to the extent that during the course of discussion the learned lower appellate court found that benefit of two debit notes issued by the respondent company. Stop. Further, the amount as principal only was directed to be reduced from the amount claimed in the suit, which included interest, also as the benefit was required to be given from the date the debit note was issued and the interest calculated accordingly. Review application was filed. Stop. However, the same was dismissed as time barred even though error was admitted. Stop. The respondent is in appeal before this court against the judgment and decree of the learned lower appellate court, which is still pending. Stop. The execution filed by the petitioner is also pending. Stop. The principles laid down in the above mentioned judgment have again been reiterated by this court, wherein this court held that the defense raised by the appellant company. Stop.